Welcome to The Explainer. Today, we're diving straight into a foundational legal tool, one that solves a common dilemma almost every single one of us will face at some point when managing our personal or professional affairs. We're demystifying the power of attorney. Now, think about this for a second. How exactly do you sign a contract, close on a house, or manage your bank accounts when you're literally thousands of miles away? Or, maybe you're physically unable to get there. You can't just clone yourself, right? But the law actually provides a mechanism that's kind of the next best thing. It bridges the gap between your physical absence and your need to take action. So here's our agenda for today's explainer. First, the basics of POA. Second, when do you actually need one? Third, the 4 types of POA. Fourth, POA versus a letter of authority. And finally, execution and legal rules. Let's get into it. All right, Section 1, the basics of POA and who is who in the room. So what are we talking about here? A power of attorney, or POA, is just a legal document, but it's a powerful one. Through it, one person delegates authority to another person to act on their behalf. We're talking about making decisions regarding business, finance, property, the whole shebang. At its absolute core, this document is all about extending trust. You're officially handing over your legal capability to someone else because you just can't be there to do it yourself. To really grasp how this works, we've got to look at the cast of characters. The person actually giving the authority, they're known as the principal, though you might also hear them called the grantor or donor. Then, the person receiving all that authority is the agent. They're also known as the POA holder, Donnie, or attorney. Your agent can be a family member, a friend, or even a professional, though, as you can probably guess, people usually pick close family members because, well, this kind of relationship takes a massive amount of trust. Moving on to Section 2. When do you need one? Let's look at some real-world scenarios for delegation. So, the real necessity of a POA pops up when you just can't manage your own dealings. First off, geographical unavailability. A really classic example here is non-resident Indians, or NRIs. They buy property in India, but obviously can't just fly back every time they need to manage or register it. Second is physical or mental incapacity, like from an illness or an accident. Third, old age. It's super common for elderly parents to execute a POA so their kids can smoothly handle their banking and property transactions. And finally, administrative efficiency. Huge corporations use POAs all the time so employees in different regions can legally represent the company. Because, let's face it, the CEO can't fly everywhere at once. And that brings us to a brilliant caveat from our source material. A person incompetent to contract cannot validly execute a power of attorney. This is absolutely crucial, guys. You literally cannot give away power you don't legally possess. If someone is already incapacitated or of unsound mind, it is simply too late for them to sign a new POA. You have to be legally competent at the exact moment you grant that authority. All right, Section 3, the 4 types of POA, from broad control to surgical authority. Let's break down this spectrum of power, because it really varies. First, you have a general power of attorney, or GPA. This gives the agent super broad authority over a wide range of matters. It's a sweeping delegation. On the flip side, a special power of attorney is totally surgical. It limits the agent to very specific acts, like maybe closing a single bank account or finishing one specific business task. Then, looking at the timeline of the power, we have a revocable power of attorney, which means the principal can cancel the authority at any time. And lastly, an irrevocable power of attorney. This explicitly states it can't be revoked, though, legally speaking, a principal can often still cancel it by issuing a public notice in newspapers. Now, what's really fascinating here is just how fragile a standard revocable POA actually is. It doesn't just end when you say I revoke this, it's automatically canceled without any extra paperwork if either the principal or the agent becomes of unsound mind, or if either party dies. And get this, it also terminates if either party is adjudicated insolvent, which basically means legally declared bankrupt by a court. And naturally, if it was just for one specific business task, once that task is done, the power naturally expires. Okay, but what about those irrevocable POAs? We just mentioned you can usually cancel them with a public notice. Well, there are 2 strict exceptions where an irrevocable POA is truly locked in. First, if the agent themselves has a personal interest in the subject matter. In that scenario, you absolutely must have the agent's consent to revoke it. Second, if the agent has already partially exercised the authorized act. You can't just strip them of the right to finish what's already in motion. The law steps in to protect the agent when they already have skin in the game. Moving along to Section 4, POA versus letter of authority and knowing the difference.
So let's contrast their purpose and authentication. A letter of authority, or LOA, is really just meant for specific, simple administrative conveniences. Think of an employer authorizing a staff member to go pick up some documents. Because the stakes are so low, the authentication is super light, usually just a simple signs letter. A POA, on the other hand, handles heavy, complex legal matters. Because of that, the authentication is rigorous. It generally requires the payment of stamp duty, formal notarization, and hey, if you're using it in another country, it even requires an apostille to be considered legally valid internationally.
But, even more importantly, these two documents create vastly different working relationships. An LOA establishes what we call a master and servant dynamic. The tasks are carried out under the strict, direct supervision of the person who wrote the letter. A power of attorney, though, creates a principal and agent relationship. The agent gets a much higher degree of independence. They aren't just following micromanaged instructions, they're actually stepping into your legal shoes to make decisions for you. And finally, Section 5, execution and legal rules, making it binding. Now, according to Indian law, execution isn't just about casually signing a piece of paper. It has to be validly executed by the grantor. Plus, in India, POAs are subject to state-specific stamp duty. This falls under Entry 48 of Schedule I to the Indian Stamp Act 1899. And the rates? Well, they're going to vary from state to state depending on whether the POA is granted with or without consideration. It's also pretty interesting to note that while Indian law doesn't strictly force the agent to sign the document, international practices usually have both parties sign it in front of witnesses, just to officially confirm acceptance. So, what's the big takeaway? The crucial point is you've got to draft this document carefully to strike the ultimate balance. You want to get the work done despite your unavailability, but you have to be strategic. If you restrict the powers too much, your agent won't actually be able to help you, and that completely defeats the purpose. But if you make those powers too broad, you're opening yourself up to a huge risk of misuse. It really is a delicate tightrope walk of legal drafting. Which leaves us with this final thought. Think about the legal delegations you might currently have or the ones you might need to make in the future for your aging parents or your business. Have you granted too much power or just enough? Take some time to review your own authorizations and make sure your assets and your trust are properly protected. Thanks so much for joining me for this explainer, and I'll see you next time.